Okay, good morning, everybody. My name is Alan Tannenbaum of Tannenbaum, Lamole, and Hill. I'm here today with my partners, Cindy Hill and John Lamole, and our associates, Jim Turfs and Jennifer Hicks. Just to tell you a bit about our firm, we're a full-service community association firm. We also have a construction practice. Primarily John Lamole and myself administer. So we handle all the basic needs for condominium associations, and really a subspecialty on the construction side. The new legislation that the legislature came out with, we covered it in the last session in kind of a 5,000-mile overview. There are several questions that we've gotten on some key areas of the legislation, and that's what we're going to cover today. So with that, I'm going to turn the over to my partner, Cindy Hill, who's going to introduce what we're going to be covering today.
Good morning. So we've tried to whittle down some of the bigger issues we see boards needing to deal with for this presentation. So as you can see on the screen here, we're going to go over website requirements for HOAs and condos, the new ones, the new board director education requirements for HOAs and condos. There's some new official record retention and related viewing issues that are new in the laws we're going to go over. Meeting and owner participation at board meetings for condominiums is a new issue. Recommended board policies and required board policies by the new statutes, financial reporting, and then criminal penalties. Finally, ending with what Q&A we can do at the end here. So with that overview, I'm going to turn it over now to my Associate Attorney, Jennifer Hicks, who's going to start us out with the website requirements. Jennifer?
Thanks, Cindy. So as most of you know now, not only are smaller condos now required to have your websites, the threshold, is now 25 or more units, and your websites have to be up and running by the 1st of January in 2026. HOAs, you have now joined the fun of websites, and if you have 100 or more parcels, you are required to have a website up and running by January of 2025. Both HOAs and condos have official records that are protected from owner review. These are also protected on the website, either not posted or redacted. Now, depending on what the document is either you're not going to post it or you're going to have to redact information included. Both HOAs and condos have to have a public access portion of your website, which is where you're going to find generally your governing documents, and a members only or owners only private subpage, which is where your financials and other details will be locked behind a website. The associations must provide usernames and passwords for owners to access the private section as long as they've been requested from an owner. And then condominiums, you do have a couple of extra requirements. You are required to have an independent website or web portal that is either wholly owned and operated by the association, or that's leased from a third-party provider, which you pay for access or use of. And then you have to have the right to operate that page and dictate what goes on it. Also, for condominiums, if you do end up disclosing information that you're not intending to, you're not going to be liable as long as it was not knowing or intentional. And so this time, at this point, the HOAs do have your list of items, as you can see on your screen. It's going to be your documents, your governing documents, your list of contracts, your bids, your annual budgets, your annual financials, and your monthly income or expense statements, your insurance policies, your certificates of education, as we'll go over next, your contracts, anything regarding your documents showing conflict of interest for the board, and your notice and agendas have to be posted. Your notices also have to be posted in plain view or somewhere where it's clear that that's where you're going to be looking for notices. Next slide, please. Condominiums, your list has not changed. Again, it's just a threshold. The only change this year, in addition to the lower threshold, is your copy of your association building permits are now required to be on the website as well. So that's going to be sort of like your roof or your HVAC system, not the individual owner permits. Okay. Now, this year, a lot of changes came through regarding education for board members. For homeowners associations, within 90 days of being elected or appointed to the board, you are required to take an educational course that's been approved by the Department of Business and Professional Regulation. And the education has to include training on financial literacy and transparency, record keeping, levying of fines, and notice and meeting requirements. You have to do that at least every 4 years, so your certificates are good for 4 years. Addition to that course, if your association has less than 2,500 parcels, you're required to complete at least 4 hours of continuing education per year. If you have 2,500 or more parcels, you have 8 hours of continuing education per year. If you do not file your educational certificate timely, you are deemed to be suspended from the board until you have completed your education. Condominiums, yours has increased, your education has increased. You now have to certify that you've read your governing documents and will uphold them to your best ability. Before, this was an option. You also have to take a specific lineage of courses or type of course approved by the DPBR. But your course is at least 4 hours long, again, including specific instruction on milestone inspections, structural integrity reserve studies, elections, record keeping, financial literacy and transparency, levying of fines, and notice and board meeting requirements. Now, if you have completed this within a year before your election or appointment, then it is satisfied, or you have to do it within 90 days of your election or appointment. Your written certificates are good for 7 years as long as you serve without interruption for those 7 years. But in addition to your 4-hour course, you must also obtain a 1-hour continuing education credit within a year of that 4-hour, and then annually every year. And again, if you do not timely file your certificates, you're deemed suspended until you've complied. And I think, yes, Cindy, I think you have official records.
I do. I see some questions in the chat about what DBPR is doing with these requirements for new education courses. All I can say is watch this space. The DBPR is trying to put together and has their own approved course for the condominiums, but it has not gotten much further than that, and we don't have any more information on that, unfortunately. A lot was dumped on them by the legislature in pretty quick time. So we don't have specifics on that, but we're going to be watching it and letting folks know when we have more information. And going on now to official records for condominiums. Some of the changes in the legislature for this particular session included several new requirements for what are now official records. And those are up on the slide. I know this is a bit of a wordy slide, bear with me, but I did put the statutory terms in there and the citations so that you could note them. So official records now include all invoices, transaction receipts, or deposit slips that substantiate any receipt or expenditure of funds by the association. I've discussed this provision in several presentations and am yet to really figure out what the legislature thought they were doing, requiring us to get deposit slips in an electronic world where everyone's banking is pretty much electronic and able to get what you need in terms of on a website. But that being said, be aware of this. So if you do have some situation where one of your volunteers deposits some petty cash in the bank, they need to keep that deposit slip. Next, they've included now all building permits. It just says all building permits. So we've gotten some questions. Does that mean unit owner building permits? Well, the statute isn't clear, but I think you can safely make the presumption they mean association building permits. So if you've had a new roof put on one of your buildings in your association, you want to make sure that permit is now part of your official records. And then a copy of all satisfactorily completed board member educational certificates. So when your board members complete their courses, they need to make sure to get those certificates to the manager, to the secretary, whoever's organizing those records. So there's now some new requirements for owner personal information. I put the whole statute up here. What it really means in summation is that if a unit owner has opted in to receive electronic notice, their email can now be shared with the other owners, not shared with the outside world, not shared with third parties, but shared with other owners, unless they opt out of that. So now you have yet one more opt out to keep up with, association managers. Hopefully most people won't mind having emails shared amongst the community, but there are going to be a handful of people, I'm sure, that will. So you want to be aware of that. And then there's now a specific duty that if you're providing documents to third parties, as an association, you need to make sure you redact any personal information. So that was something that lawyers who practice community association law and litigators would have advised you anyway, but now this is something that's in the statutes, that obligation is there. Finally, for this slide, there's a new requirement to organize official records. As you can see, official records now must be maintained in an organized manner that facilitates inspection of the records by a unit owner. So the days of putting an owner in a room with 5 boxes of documents are over. You're going to have to be more detailed about how you organize your records. There is an obligation now, and this has come from the legislature really reacting to owner complaints they heard a lot of this very year. So if you're not already keeping your records organized in a manner that's going to facilitate owners being able to find them, you're going to want to come up with some strategies and some plans for that, because that is now a requirement. Also, if official records have been lost or destroyed or otherwise unavailable, an association now has a good faith obligation to obtain and recover those records as reasonably possible. So what does that mean? Because in the association world, unless your community is only a few years old, you've probably got some records that maybe a board member took home and put in their unit. Maybe you changed management. You probably got some records that are waifs and strays, so to speak. And if you're an older condominium, you may have some documents going back up to 7 years, which is the requirement for keeping most records, that you're not even sure where they are. So if you're the latter situation where you know that you have some missing records, my recommendation to you is to get out there and start trying to find what is missing, and if you can't find it, making efforts to document that you at least tried, that you made the good faith effort, and be doing that before an owner starts requesting those records and then accuses you of not giving those records to them because that you don't like them or some other personal agenda, as opposed to you just not having the records as a matter of business. So this is putting some pretty heavy burdens on condo associations. Next slide.
Hey, Cindy.
Oh, yeah.
Cindy,
Go
is there
ahead.
any guidance on, do you actually have to keep paper copies, or is it okay to like scan stuff in and keep all of this information electronically? Because I know that in some instances where, you have a records request, oftentimes, the member comes in and sits at a computer in the manager's office and looks through computer files. So is that still an option, or?
Well, the new laws don't provide any restrictions on providing access to paper or website, electronic. But they do now include that if you put them on a website, you can tell an owner they're available on the association's website and not have to produce the paper copies. But that being said, on the flip side, there's not a burden. I don't want to freak everybody out on the webinar here. There is not a burden to get everything immediately electronically up on your website. That is a way the legislature is leaning. As Jennifer was saying in the earlier part of the presentation, there now are documents you need to be actively putting on the website now. But at the same time, you're going to have historical documents that maybe aren't on the website right now. Maybe it would be onerous to go on a website right now. So those are still going to be available to owners in paper copy. So let's see. Okay. And that dovetails right into the next slide. So if they're, again, for condos, if the requested records are available on the association's website or available for download on an app, I don't know that many people are going to choose an app for their association, but if you do, that works too. The association fulfills its obligations to provide records by directing the person who requested them to the website. So for instance, if you get an official records request that says, I'd like to see, the board meeting minutes for this year. If your board meeting minutes are on your website, and if you're one of the associations that fits the numerical requirement, they will be, you can respond and say they're available on the website. You don't have to schedule a meeting. You don't have to coordinate them coming in to review them. That's sufficient. And then I get some questions about, well, what about people, because we are, still mainly a retirement area around here, people who have decided, they're just not going to get on board with the internet, not have a computer, and don't want to use a website and don't know how. Well, the legislature is basically leaving those people in the dust because it doesn't place any alternatives. It says if you provide access on the website, that is sufficient. So what's the answer for some of these people? Well, as John was saying, someone can come into the management office and look at the website there. I also encourage, in the interest of managers and volunteer board members already have enough to do, tell someone, that their public library is a good resource for this. They can go to the public library, look at a website, a librarian, I'm sure will be happy to help them. So I bring that up in terms of the world, really, the condo HOA world in Florida is really going website, really going electronic. So to the extent these burdens might seem onerous right now, my prediction is in the next few years, they're going to make everyone's life a lot easier. You're going to be able to tell owners their documents on the website. You're not going to have to worry about scheduling things. You're not going to have to worry about somebody complaining because they don't like your hours. It's going to be electronic. That's where all of this is going. But returning to the burdens that the legislature has placed on association, condominiums, not homeowner associations, but condominiums have the obligation now to make a checklist. This is even for the website option, to show what owners requested and what they provided or did not provide. And this goes back to why it's going to be important to know that you do have your historical documents to your best knowledge, and if not, hunting them down. Because you're going to have a checklist that tells the owners, to the extent they ask to see the board meeting minutes for this past year, that you told them they were on the website. The extent they ask to see the original building plans, maybe you let them come in and look at those, but you have to have that checklist. It has to be a form. There's no statutory form, but it can't be, it can't be just some scribbled notes. You're going to have a form you want to use consistently that shows how you responded to each owner, and you have to keep these for 7 years. So again, I don't have advice as to a specific form, and I don't think you need to worry about the details of the form. It just needs to be a usable form you use consistently that meets this burden. So next slide, please, John. So with that in mind, I do have some recommendations for condominiums to consider, again, considering your age, your circumstances, for policies. You might want to establish guidelines, again, depending on the size of the condominium too. You might want to establish guidelines to collect copies of invoices, receipts, or deposit slips from volunteers who may not otherwise be organized enough to save those. You might want to have a system of record organization that is agreed to basically by management, board members, and other volunteers for the maintenance of records. If you're a large one and you've got a number of people sorting records and putting things in certain places, you want to make sure it's going to be consistent. Establish a system for addressing and documenting efforts to resolve records that are lost, destroyed, or otherwise unavailable. Again, if you're an association that there's a significant, or let's hope not significant, but maybe there's a chunk, let's say, of records that you don't currently have because of either past management, past volunteers, maybe something got damaged in a flood, you need to have a policy to search those out. Again, with the idea being you don't want owners to take it personally when you don't give them records. You want to be able to show that there's bigger issues at play, so to speak. And finally, have the board approve a form checklist that's going to be used for all the official records requests. So next slide. Now that hopefully the homeowner association people can put their attention back in here now, because I'm done with that long burden on condos and now returning to your official record burdens. Homeowner associations now have the obligation to deliver a physical or digital copy of all their governing documents to their owners by October 1st, 2024. I don't know why the legislature thought this was a great idea, but they obviously did. This is a burden that can be met by sending out an email to your owners who have accepted notice by email saying, hey, these documents are available on the website. If you haven't had email notices, you can send a letter out saying, hey, these documents are available on the website. You can also say, I've had some associations say that, you can contact management for a copy, or we keep an extra copy in the clubhouse. But this is a burden now that by October 1st, you're going to need to make sure that you've met. And then going forward, every time there's an amendment, you have to do this as well. So the more owners you can get to read electronic notice, the more you can keep your website up to date, the easier this burden will be. And going back to policies, this is one where now homeowner associations are obligated to adopt written rules or policies stating how official records are maintained and the time period that they must be maintained under that section of the statute there, 723.034. And generally that time frame is 7 years. There's some exceptions that are stated in the statute, but it is 7 years. So I'm going to Jim Turfs and I have done a number of these presentations where people ask, well, what is that? Jim says, your policy really can be cutting and pasting what the statutory requirement is. And I agree with Jim. 723.034A, cut and paste that out of the statutes, tweak it accordingly for your association, and you have your policy. But you do now have to have a policy. Okay, next slide. Let's see, now we're returning to condominiums because we're moving out of official records into meetings. And there are now a number of new requirements for condominium association board meetings, including the first one is that they now have to, unless you're smaller than 10 units, you now have to meet at least once a quarter. Once a quarter, not 4 times a year, once a quarter. So if you haven't been doing that and you're larger than 10 units, you're going to need to change your practices. Moving on now to what owners' participation can be at board meetings, there's a number of changes here. At least 4 times a year, now not once a quarter, but 4 times a year in this case, the meeting agenda must include an opportunity for members to ask questions of the board. So you're going to have 4 times a year an agenda item that lets owners ask questions. And I've had some participants at these seminars ask, well, can we have a meeting just to do that? Well, doesn't say you can't. So if you want to, you can have what you might call a town hall meeting where the only issue on the agenda for the board is for owners to ask questions. And that would actually be potentially a good idea if you got a large community where people ask a lot of questions, because you wouldn't be trying to get business done in addition to listening to questions. Alternatively, if you don't get a lot of owner participation, you can put that agenda item on a regular board meeting and proceed. In addition now to the right to speak to agenda items, owners have a right to speak, and I'm going to quote from the statute here, with reference to all designated agenda items and the right to ask questions relating to reports on the status of construction or repair projects, the status of revenues and expenditures during the current fiscal year, and other issues affecting the condominium. That last one there is pretty broad. So to the extent that meeting efficiency was being followed by utilizing the right that owners had to speak to an agenda, but not necessarily other issues, that is over. You now pretty much need to let owners speak as to whatever issues they bring up that are, at a minimum, issues affecting the condominium. That being said, depending on how many questions you get, how many repetitive questions, keep in mind it doesn't obligate the board to actually answer. It does say that owners can ask questions. And I mention this not because board directors don't want to keep their owners informed, because in some large communities, there could be a lot of questions, and these could turn into some long meetings. So that's just something to keep in mind, that if you are in one of those larger communities and you get a lot of questions on a regular basis and you're thinking, oh my word, how are we going to keep these meetings moving? Keep in mind, it does not obligate you to respond. It just says they have a right to ask questions, and you can tell owners something along the lines of, we thank you for your thoughts. We will consider that. Next question, please. If you're a smaller community and people do have questions, you might just want to address them there and let them feel that they got communication, because that's what I've heard where this legislative intent has come from, is owners were complaining to the legislature that they were not getting answers to questions, their boards weren't listening to them, and they wanted a mechanism to be able to have more communication. Okay, so another burden now for condominium associations and not for homeowner associations is if you are going to have a board meeting that relates to the approval of a contract for good or services, and I read that from the statute, you have to copy that contract with the notice. And it needs to be available for inspection and copying upon a written request from a unit owner, or made available on the association's website, or again through an app. So what this means is if you think the board is going to be approving a contract, let's just make this up, a painting contract to, I don't know, paint the entrance building, the gatehouse building, you're going to need to have that contract provided with the notice that will of course go to the board as part of the board package. But what I don't think the legislature considered here is the posted notice that needs to take place. So now you're going to be needing to post contracts on the site, on the area of your property where you're posting notice. And it's going to be impossible to post some of those contracts, because if you've got a big engineering issue that needs to be addressed, you could very well have a very long contract. So this really has some impractical considerations. But the idea is to let owners be able to see the contracts before the board agrees to them. So if you do have a very long or onerous contract and it really can't be posted, my recommendation is you consider putting a note next to it saying that the contract's available, but with management, or available if they want to email a board director, however you want to handle it, but make sure they can get a copy of it so that you are in compliance with this. I did notice a question earlier in the chat saying, well, what happens with this? With bids and contracts basically being available for owners, vendors aren't going to have necessarily a feeling that their work product contracts are going to be protected from public view. That's not a consideration the legislature really seemed to consider here. All owners, so if you got like, I don't know, a 350 unit condominium, all owners are going to be able to see a painting contract. And if it just so turns out that one of those owners has a buddy who's a competitor, yeah, potentially these things could be shared, but that's an issue the legislature, I don't think, considered, honestly.
Cindy, a clarification on that, because I think the specific question I saw was about bids before you get the contract. And I don't see a requirement here that, at least for a condo, that bids be attached to an agenda item. But would you consider bids to be official records of the association, that if there was a records request, that there would be no way of getting around having to provide owners with bids on a contract that has not yet been let?
Well, bids are definitely part of the association's official records. So the association has to maintain its bids. Associations have a duty to show that they got competitive bids for certain projects if they're over 5% of the association's budget. So whether or not they would need to attach a bid, though, to this new requirement would depend on if they're going to accept bids or not. In terms of, let me clarify that. If they're going to sign a bid and treat it as a contract.
Right.
Because this does say contract. So they didn't really word it well enough for us to nuance this, other than I would take the position, if the board is going to agree to a financial obligation related to a piece of paper at a board meeting, that piece of paper needs to be provided. Because in some cases, boards do just accept bids as written. There's not necessarily a formal contract. It really can depend on the project.
There's a question in the chat. Can you summarize long contracts and leave off the terms which the owners can request at some point, other point? I'm guessing that summarizing a contract is probably not an advisable thing, both because of the statutory language and also just the inherent problem of perhaps summarizing it in the wrong way that could create some sort of liability. Would that be a fair statement to make?
Yeah, I would not recommend summarizing it, because no insult to anyone, but you'd be summarizing something that's probably not in your industry, and you may not do it in a way that would convey what the actual document does. And you don't want to be in between this requirement that owners have information and somehow be an impediment to that. So if it's too long, I've suggested in some cases, if you can take a page and to put 4 pages on one page, for instance. If you got a 12-page contract, you might be able to post it doing that. If you've got a 35-page contract, post the first few pages, and again, tell them that how they can easily get a copy of it. It's onerous. And I believe that that's one of the issues the legislature intends to correct. Because keep in mind, these have to be put on the website as well. I think I sometimes get a little too caught up in the problem the posting creates and forget to say, this has to be put on the website. So the board package that goes out to the board with let's say, again, a painting contract on it, also has to be posted on your website. So owners are going to get copies of these documents quite easily now. And the hope would be that they don't necessarily do anything other than go, oh, our association is going to get a painting contract. I'm not necessarily going to pull that down and share it with their competitors. But we'll see, I guess. So go ahead.
There's a lot of stuff on the chat. I think you've struck a nerve here, and there seems to be a lot of discussion about contracts versus bids versus estimates versus quotes. And I think maybe the takeaway here is not to get hung up on the title of the document. If it is a document which the board is going to consider that will obligate the association to pay a certain sum of money in return for a certain provision of certain services or materials. What you may call the document is irrelevant. It's the document that is going to bind the association to a financial obligation. And so therefore, that is probably what the legislature means when they say contract. Would you agree?
You nailed it, John. I don't really see how else to read this in terms of contract is a loose term legally in terms of what really matters is it binding? Is it an agreement the association has made? Are they going to be paying funds? That's certainly the best way to handle that. And I know this is going to make meetings onerous to a certain extent. And I know that associations that have some, let's just say, owners who have a voice and don't mind using it, it's going to give them some information that they're now going to be, maybe questioning at board meetings. There's going to be some burdens here. But I think on the flip side, you want to remember that the legislature really wanted owners to have the opportunity to see what business decisions are being made in the condominium. That they just heard from too many owners that they don't know what's happening. It's hard for them to get records even when they request them. So the transparency is, I think it's a burden, but it's overall going to be a good thing. And again, to the extent that the posting issue gets dealt with by the legislature, and I think it will, the physical posting on the property, you're going to have to put these on the website. But for those owners who want to keep up with what's happening in the building, it really will be a good protocol to have, where people are not going to feel so ostracized that they don't get their questions answered. They don't know what's happening. They don't understand. They're going to have a website that's going to have a lot of answers for them now. But yeah, John, that's exactly right. Don't get caught up on the terminology of that. So just to wrap up this part of it, because I've taken a little more of my time, a little more time than I should have here. Policy recommendations is establish a board meeting schedule that fulfills the new meeting requirements. Again, if you are more than 10 units and you're not meeting at least once a quarter, you need to revisit that. Establish or amend your meeting attendance policy to provide guidance for these new owner speaking rights. Get with your council on that, particularly if you're a large community and you're concerned how these meetings might go on 3 hours. Those are things that are valid concerns. You need to discuss them with your council. And finally, establish a policy for posting contracts on site and online, and have guidelines in place for lengthy contracts. Sorry, there's a typo there. Going back to what we were discussing, get with your association council, get their recommendations on best how to make sure you're meeting these new statutory requirements. So John, did you want to bring up any other questions before we turn this over to Jim? John, I think you got muted. You did, you got muted.
No, let's keep it moving. I will continue to monitor the chat as needed.
Okay. Well, I'm going to turn this over to my colleague, Jim Turfs now.
Hi. I'm going to talk about the glorious and glamorous world of financial reporting to start with. And while I say that with a joking tone, it's certainly not a fun subject for anybody. It is very important. And while the changes were relatively minimal this year in that regard, I think it's important that everybody understands what a director's responsibility is when it comes to working with financial reports and the level of reporting that goes both to the owners and kept as a matter of the board. So to start with, the statutes make it pretty clear that the association has a responsibility to keep their financial records in accordance with good accounting practices. Now, what that really translates into for your directors is work with an accountant. Don't have the retired CPA who's acting as the board's treasurer be responsible for all of your financial record keeping. Certainly they have a role to play, but going forward, you definitely want to be doing a lot of your financial work in conjunction with an accountant who's familiar with managed community accounting practices. So as a combination there, certainly your treasurer can be well informed enough to maintain the records on their own, but at the very outset, especially with new directors, make sure everybody understands what the requirements are. Make sure that you've got an education from an accountant, because there are a lot of terms of art involved here that are terms of art of the accountancy world. They aren't necessarily something your lawyers are in a position even to educate you on. So I'm not going to ask you to memorize section 2, because again, you should be working with an accountant who's going to instruct you on this. But generally, you'll see the list of documents that an association needs to keep as far as official records and financial records for the association. Again, these are the documents that your accountant's going to be relying on when they generate your financial reports, which we'll get to in a brief second. But if you look at item D on that list, which is any other records that identify, measure, record, or communicate financial information, you'll understand that's a really big catch-all. And so my advice is, don't necessarily be married to this list. Just keep anything that has to do with association finances, whether that's money coming in, money going out, or just moving money within association accounting, different accounts, transferring from reserves or operating, whatever. Keep every record. No association's ever been punished for having too many financial records, but if you have too few, you're asking for trouble. Go to the next slide. So here's a little bit more about the practical stuff that directors need to be aware of when it comes to financial reporting. So every association is required annually to produce some level of financial report. And as you'll see, within 90 days after the end of the fiscal year, and for most associations, that's going to be December 31st of the year. Most associations run on the January to December fiscal year. Your governing documents can change that. Some of the older associations adjusted their fiscal year based on when they turned over. And as a result, you do have some associations that have wonky fiscal years. But let's assume you're working with the December 31st date. The association has 90 days within the end of that previous year to have the financial report prepared. And again, that's a document that's going to be prepared by your CPA, your association accountant. After that report is prepared and the association receives it from the accountant, it needs to be made available to the membership within 21 days after receipt. That doesn't mean it has to be hand delivered. You can hand deliver it, you can mail it, but it just needs to be made available. So as Cindy and Jen as well described some of the website requirements, you can make your financial reports available behind that private section of the website, put it on there as long as everybody can access it. And you just need to then make sure everybody is notified that, yes, the financial report is available online. For condos specifically, if an owner comes and asks for it, condos are required to provide it within 5 days of the request. So keep your financial reports available. Know that they can be requested. If they are requested after that 21-day period after receipt of the report, it's a 5-day response deadline. It's not your typical official records request. Financial reports have to be presented a little bit quicker. So you'll see on item 3 that I also talk about the various brackets of financial reports and what's required. I'm not going to explain to you what each of these levels requires as far as your financial reports, because that's your accountant's job to do that. Work with your accountant. Don't focus on that. Just make sure your accountant's familiar with their requirements and they will do what's required. So, but generally speaking, it's based on revenue. And again, I talk about terms of art in accountancy world. Revenue is one of those terms of art. Not all of the money you make is necessarily revenue. So again, make sure your accountant is looking at that. So, but for an association that makes between 1 cent and $149,999.99, you have the lowest level of financial reporting, and that's a report of cash receipts and expenditures. For associations that have revenue between $150,000 and $300,000, you have to generate a financial report comprised of compiled financial statements. $300,000 to $500,000, you have to do reviewed financial statements. And of course, for associations that are taking in revenue of $500,000 or more, you have to do audited financial statements, which is, of course, the highest standard of financial reporting. Also, for HOAs, and this is unique to HOAs, if you have 1,000 parcels or more, you're going to have to do audited financial statements regardless of what your association's revenue was for any given year. So again, the directors need to be aware that these are the requirements. Your accountant needs to be the one who's preparing these reports, and you need to make sure they're delivered appropriately when it comes time at the end of the fiscal year. If you want to skip to the next slide. Now, this is where some of the newer statutes have come into play, and they've changed things a little bit. Now, the board can be required to move up its required level of reporting. So let's say you make less than $150,000 in revenue, you have that minimum receipts reporting requirement. If 20% of the membership petitions the board, and then the board has to set a meeting, and then at a meeting, the majority of the membership votes to do so, you can actually increase that level to, you can go as high up as audited financial reports if that's what the membership wants. That's a really weird procedure. I've never seen it done, but it's something that could pop up, and it's something you need to be aware of. On the other hand, what we do see very frequently is the board asking the membership to vote to approve a lower level of financial reporting. So let's say you've made $510 of revenue for a fiscal year. Rather than paying for a full audited financial report, the board can set a member vote, and if a majority of the membership says we vote to approve reviewed financial statements, a lower level of reporting, they can certainly do that. But under the new statute, which became effective July 1st of this year, you can only do that once every other year. So at least once every 2 years, an association has to meet the statutory reporting requirement when it comes to finances. You can't consistently vote to report less than what is required on the previous slide. And that's important because that's new. Previously, we had a lot of associations who would every year conduct that member vote to reduce the level of financial reporting. It saves money. A lot of owners don't look at these financial reports, so it's something you could sort of get away with. But as a result of a lot of the financial fraud, embezzlement, misuse of funds that have been publicized recently, especially out of South Florida in the past couple of years, the legislature has sort of corrected that and wants to make accounting more transparent for the membership so that in the event money is disappearing, it's a little bit easier to discover. And if we'll move on to the next slide. And so next we talk about the other new portion of these statutes, which so far as a firm, we've been not really talking about because quite frankly, every act that the new statutes have identified as a crime punishable by, imprisonment or fines, whatever, they were always crimes. They've just now decided to put them in chapters 718 and 720 to say, all right, here it is. It looks more severe. It certainly maybe gives members a little more feeling of security, and maybe it scares some directors a little more. But these were always crimes. So, don't do crime. You're generally going to be okay. But just to recap briefly what the statutes now say about that, in particular for HOAs and condos, they've identified certain felonies. As you see, if a director, officer, or manager accepts a kickback, which is defined by the statutes as basically taking a financial or other type of payment for work given to the association as sort of a inappropriate kickback, it's going to be a third-degree felony. Any person who willfully or knowingly refuses to produce association records with the intent to avoid criminal prosecution is also going to be committing a felony. Now, that is sort of new, and that's maybe not something people would have thought of in the past. But if you look at how many different individual elements are required for that to happen, you'll understand it's very rare. A director would have to, or a manager for that matter, would have to knowingly refuse to produce a document. So it's not that they've accidentally done it. They've chosen not to produce those records. You can demonstrate intent. And you can also then express that you have to also prove that that intent was to avoid criminal prosecution. So, that's a pretty high burden. I don't think we're going to see a lot of directors or managers or anyone being charged under that statute, but just produce the records when they're requested and you're going to be okay. Misdemeanors, felonies come up to a year in jail time, things like that. Misdemeanors cap out at a year in jail time and $1,000 fine. Felonies can be a year or more and higher fines. But for misdemeanors, they've pointed out that, again, denying access to official records willfully, knowingly, repeatedly, and with the intent to cause harm is going to be a second-degree misdemeanor. Any person, and again, repeatedly there is one of the big key words, as well as knowingly. So technically, under that statute, you can once a year or once every 2 years knowingly and willfully withhold records with the intent to cause harm and not be subject to punishment. It has to happen at least twice in a 2-year gap. So again, sort of an unusual and somewhat absurd thing to put in the statutes, but it's there. Destroying accounting records to avoid criminal prosecution is a first-degree misdemeanor, and again, that's up to a year in jail and $1,000 fine. Honestly, if you're at the point where you're committing accounting or financial fraud, destroying or defacing the records is probably the least of your worries. But it's something that they can also now tack on, and something that, again, has come out of those South Florida prosecutions involving directors and boards who were, paying for their vacations and things like that out of association funds. And finally, voting fraud. And again, this is maybe something that people don't think of in the context of being a crime, but certainly is now. And you can review either 720 or 718 to see the actual statutory list of every item that they're going to consider as voting fraud. But generally, you can't go around bullying people. You can't offer to buy votes. You can't threaten them. Really just stick to what the statutes say as far as your elections and the voting process. Send out your ballots when you need to send your ballots, have your votes when you need to have your votes, and just generally don't interact with the membership beyond what's done at open board meetings or through statutorily required notices. You're going to be fine. And as you'll see in my note 5, just generally use common sense. If you find yourself asking, hey, I wonder if this is a felony or a misdemeanor, you're doing something wrong. Don't do it. I mean, it's pretty simple. And as long as you just do your jobs and use common sense, you're gonna be okay as far as the criminal statutes go.
Yeah, question for everybody. Cindy, Jim, or Jen, because I've seen it now come up in the chat quite a few times. Is you have all these new requirements placed on boards and associations, and the question that is asked is, what is the association of the boards or management's obligation, if any, to let their members know of these new statutory requirements and perhaps new statutory rights that are created for members? It would seem to me that at least, in what reading I've done of the statutes, there's not necessarily for most of this any affirmative obligation to educate your members. But you guys do this way more day to day than I do. So is there some duty for the board, the association, to notify members of any of these new obligations that are placed on the association?
Well,
No,
go
I
ahead,
certainly
Jim.
haven't seen any affirmative requirements for CAMs to directly educate members really on anything. Now, practically, there might be some things that everybody's going to benefit from if they do provide a certain level of notice or education about some of the newer changes. But a CAM's duty is generally going to be to the board and the association, not directly to the membership in that regard. So certainly under the CAM, some of the newer versions of the CAM statutes, CAMs have a duty to provide certain education and take steps on behalf of the board. Otherwise, they're going to be facing a breach of their statutory job requirements, basically. But no, by and large, I'm not aware of anything that says they have to go out and explain anything at all to the membership.
And that's the same for the board, not just the management, but the board doesn't have an obligation to educate the membership just generally. They have an obligation to do affirmative actions they're obligated to do. Like I'll give the example of where the HOAs now have to send out the governing documents, whether digitally or via mail. That's something that the board will by default be educating the members if they didn't already have a copy, but that's a specific obligation. Other than those specific requirements, no, there's no general educational requirement that boards have for the members.
Cindy, there was a question about if the board has a policy that contracts under a certain amount can be approved by management or signed by the president without going to the board. Would those contracts have to be attached to any agenda and for purposes of a board meeting if actually board approval of that particular contract is not required?
No, they would not. If you have one of those policies where up to X amount of money can be spent by management or the president, and that was already made by a board policy that was created previously, those are not actually board decisions at this point. So the notice, the board meeting notice would not have to require them. Now, I would say be careful with that though, because if you're going to ratify a decision that got made, you're going to have to copy that. So for instance, let's say there was a small plumbing leak on property, management called out a plumber, the bill was $1,200 and, got it done quickly before it turned into something big. And now the board is going to ratify that already done work. If they're going to ratify that at the meeting, they're going to need to attach it. What the key is, if the board is going to, it's like John was saying earlier, if the board is going to make a decision at a meeting where funds are going to be expended by the association, or also ratify that decision because it got made between board meetings for whatever reason, that's what has to be attached to these notices. So I hope that clarifies, because I did see there's a lot of questions in the chat and a lot of confusion over this new requirement.
I think another corollary question to that, and we could use the example of bids. So let's say there's a project coming up. The association has solicited bids start coming in. They do at the point, I guess, that they come in, become official records of the association.
Yes.
But do those bids typically have to be published on the website, or would that be, and would there be a schedule of how soon after, like, you receive a bid that it has to appear, if in fact it does have to be on the website?
So for HOAs, your bids do have to be on the website, but not until essentially bidding is closed. So you're not required to post them. So let's say a competing vendor sees them. They are required, but not until after the close of bid. And then for the association of, condominiums, they also are required to post them. Again, it's not, it's after bids are closed. So they're the same. They have to be posted, but after closure.
So that's some good news for vendors, that people can't necessarily, be backdoor getting information until the bidding process is closed.
Well, but that, again, that's publishing on the website. But at the moment it comes in, it's an official record. And in theory, if an owner made a records request just after a bid comes in, can the publication of that bid be delayed until the bidding process is completed?
That generally, no. If the bid involved a contract that perhaps the attorneys are working on, the attorney for the vendor and the attorney for the association, there may be some work product issues there that could be protected. But yeah, you're right, Alan. If somebody really did want to kind of step in and get that information, either because they really felt like they had a vested interest in knowing or wanted to share it with a competitor, they could.
Yeah, and then on the construction side, that is not necessarily been, again, another issue that's not been properly thought through.
That's exactly it, Alan. The legislature, I believe, didn't give any thought at all. They were focusing on transparency in communities and owners getting answers to questions. They weren't thinking about what this would do to vendors potentially.
Cindy, there was and I'll open up to all of you. There was a question about management's obligation to assist the board in complying with all of these requirements. What would be your general response to that inquiry?
Jim, you want to run with that one?
Sorry, I was answering a question in the chat.
You were answering the chat. I was gonna give you a chance to talk.
The exact question is, what is the obligation of the CAM to keep the board? I'll summarize it somewhat. What is the obligation of the CAM to keep the board legally compliant?
So there, to my recollection, and we didn't talk about it today, I haven't reviewed it recently. There were some changes to the CAM statutes as far as, it can be considered a breach of duty for CAMs not to do a couple things. But by and large, that's going to be a contract-driven question. So it's going to be based on, there aren't a lot of statutes, if any, that necessarily create requirements like that for the CAM to educate anybody or keep them compliant. Because again, I think that's essentially the same thing as educating. So it's going to be, what does the CAM contract with the association say? Does it create an obligation for them to provide, frequent updates regarding certain topics to boards, things like that? But again, in the statutes, not a lot.
No, and then the CAMs can't give legal advice. I mean, that's not something they can do.
Yep.
Well, I mean, there are statutes. I mean, the statutes clearly do create some fiduciary obligations on CAMs and some new fiduciary obligations, particularly with Condo milestone and structural integrity reserve study. Those processes. I mean, I think we could all agree that a manager can't sit by and watch knowingly and participate in the board's violation of statutes and especially criminal issues, right? Because that could give rise to some sort of criminal liability on the manager's part. But I don't think that at least from what I've read, I don't know that there's specific provisions in the statute requiring a manager to educate their board members
Oh,
about
correct. Now-
about things.
What I would say as sort of the flip side of that is you're not going to be in a bad position by trying to keep your boards in line. I mean, if you see them, like John said, if you see them noticeably violating a statute or about to commit a crime or something, you should certainly step in. And sometimes it may even go so far as to be important that you send a letter advising them that they're about to do something wrong in order to protect yourself as a CAM. So, you know, if you're about to see them do something stupid and you write them an email or something that you can save as a record going, hey, I see you doing that. I don't think that's right. You should probably look at this or talk to the attorney or do something else. And they go ahead and do that action anyway, it might be very important for you as a CAM to later turn around and go, I advised them this was a stupid idea. I told them we need to talk to the attorney. Don't blame me. So while there's not necessarily an affirmative obligation, there's still going to be some common sense work in there where take a look at the situation and if you need to pipe up, pipe up.
And again, CAMs can't give legal advice, so the situation doesn't even have to necessarily look stupid. Although I agree with Jim, if it does, you need to step in and say, I don't think this is a good plan. But it can even seem that you're just not sure as a manager if what the board is doing is going to be compliant, particularly now that there's new laws to keep up with and other obligations. It certainly can't hurt to email boards and remind them that certain decisions really should involve legal counsel. And that way managers can certainly show that they put a cautionary in there without giving advice one way or the other, just advising the board that they, you know, be careful what they do and be prudent.
It would appear that the biggest obligation that the legislature has imposed on management has to do with records retention and organization of records, because generally for associations that's managed, that's where the records exist, is within the control of the management company. So, while the legislature has placed an undue burden on associations, that also means that it's a heck of a burden that's been placed on management companies, especially again in the area of notices, records retention, and so forth. Put a big obligation on management companies to organize all that. So we have hit the noon hour.
Alan,
we'll try to answer some additional questions on
I'm
chat.
scrolling through the chat, trying
Anything
to,
that any of you see in the
minute or
chat right now that you want to respond to before we close?
Well, there was a lot of questions about the board certification classes and where do people find those class offerings. I know that those classes I believe have to be approved by DBPR. Is that correct? Okay, and so is DBPR going to be maintaining a list of courses available from different vendors? Because I'm assuming law firms and other folks will be putting together those, those approved classes. But nobody seems to know where to find that information. Is there something coming up where people will be able to find that pretty easily that you know of?
They usually do maintain a list of available classes. And the DBPR, I was told recently that the DBPR said today was now going to be the day when they started offering the Condo class for free through the DBPR. But they also said that going back to, like 2 weeks ago, they've constantly said, we're going to offer the class, we're going to have all the requirements. And somebody in the chat said they were offering classes today. I'm not sure if that's necessarily the qualified class or not. But yes, it will clear up as more providers are approved. We've certainly submitted our request to be approved as a provider for the 4-hour Condo class. And we're going to do the HOA class as well. But yeah, for the moment, there's just a lot of confusion. So what I've been advising clients is just, if you see a class that is claiming to be the qualified 4-hour Condo director class, A, make sure it's DBPR approved, and B, compare it to the statutory requirements for that class. And if you look, there's a statute, and we can provide it if anybody needs it, that says the 4-hour class has to discuss milestone inspections, fining, financial reporting. It talks about the general areas that need to be included in that specific class to qualify. So, that's the best way you can protect yourself as a director trying to take these classes, is to, do as much research and just try to be as certain as you can that it is in fact the class that's being required. Because I think we're going to see some people who are either taking like the HOA class because there's a 4-hour HOA class that is very different than the condo class. We might see people just taking a 4-hour condo class that isn't necessarily designed to satisfy the requirements of the new director program. It's a scary world out there, and you need to do some due diligence. And again, if you have particular questions, you can contact general counsel and have us look at it, or contact the DBPR and say, hey, they're offering me class CE 1726. Is that going to satisfy the new condo director requirement? And they'll certainly tell you that.
Yeah, and I want to add that DBPR will have a list of the classes they're putting on, but they do not have a master list of the classes that vendors throughout the state are putting on, because they just don't have the manpower to keep up with something like that. Michelle did add to our chat that if you go to the DBPR's website and go to the education, it shows the DBPR webinar classes are being offered at this time. So that's hot off the press info. Thanks, Michelle.
This presentation will be on our website in about a week. So if you want to refer any of your board members or any of your other managers, it will be available with a transcript. So go to our website under the news section and resources section, and you'll find that, along with the videos and transcripts of most of our sessions previously, if you ever want to review them, and plus a number of articles that we've published. So until next month, we're going to say goodbye at this time. Any questions we haven't answered, we will try to get to. So thank you very much for attending today.
Bye.